Mr. Ngalo, I must place on record that, and for the benefit of my colleagues, that you've asked for an extraordinary indulgence of having to speak for 20 minutes without interruption, which I've decided to grant you and Ms. Hofmeyer. So go ahead.
Thank you, Chief Justice, and thank you, Justices. Can the country afford to have the head of a Chapter 9 institution, any Chapter 9 institution, operating under an ever-present threat of a punitive and personal court order simply for performing her constitutional functions and at the behest of powerful institutions that seek to avert or avoid accountability? In other words, is it reasonable? Is it appropriate? Is it desirable for the head of a Chapter 9 institution, any Chapter 9 institution, to be mulcted in personal and punitive costs in circumstances where she did not initiate the litigation, and also in circumstances, as in this case, where at least 2 judges have found that the so-called Bankorp life rescue, the Bankorp lifeboat was unlawful? Did the public protector abuse her constitutional powers when she investigated a complaint lodged by senior counsel of considerable experience and taking the remedial action that she did? These are the questions that this court is called upon to determine in this case. In its deliberations, members of the court will no doubt be alive, and this has to be said, to the negative public sentiment currently sweeping the media and social media in this country against this public protector. In this specific regard, we can do no better than to remind ourselves of the timely observations made by the Chief Justice last week on the occasion of the inaugural presentation of the judiciary's annual report, where the Chief Justice cautioned, aptly we submit, judges against the temptation of, as it were, sacrificing justice at the altar of public opinion. So we address the second question first, and that's the question of the declaratory order. The Reserve Bank anchors its abuse charge against the public protector, for which it asks this court to grant a declaratory order, on what it characterizes as the public protector's failure to act independently, impartially, without fear, favor, or prejudice, as Section 181(2) of the Constitution requires of her. It supports that charge, or in support of that charge, the Reserve Bank alleges that the public protector held secret meetings with the presidency, that she failed to explain what was discussed at these meetings, that she discussed remedial action with the presidency and failed to do so with the Reserve Bank, that she discussed the bank's vulnerability with the State Security Agency, that her intention was to undermine the Reserve Bank, that her explanation in relation to those meetings with the presidency are false, that her explanation that she relied on economics experts for her report is false, that her subsequent explanation in this court is too little, too late, and that she was biased against the Reserve Bank because she did not afford it the same courtesy of a meeting that she did the presidency. But the Reserve Bank overlooks a number of things in making those accusations. First, it overlooks that the Reserve Bank, like the presidency, was also given an opportunity to comment on the provisional report, and it did. It overlooks that the public protector has had no less than 2 meetings with the Reserve Bank in September 2013 and in September 2016. It overlooks that neither of these meetings with the bank were transcribed or was transcribed. And there is no conspiracy theory about that. It overlooks that the views of the bank were taken into account if one has regard to the supplementary volume. It overlooks that the real issues for the meeting with the state security agency and prefers conspiratorial reason that seems to resonate with a belief held and perpetrated by a political party. It overlooks that the April 2017 meeting with the presidency was, as the presidency email itself shows, merely for meet and greet and had nothing to do with the remedial action. But the bank prefers a conspiratorial purpose, as that seems to resonate with media-induced public opinion. It overlooks further that the mere fact that an Audi alteram partem was not observed does not by itself justify an inference of bias, as the Supreme Court of Appeal tells us in a matter which is not in our heads of argument, but is in the judgment of the High Court, and thus the matter of the Commissioner for the Competition Commission versus the GCB is reported at 2002, Volume 6 of the South African Law Reports. The judgment begins at 606, and the relevant excerpt is at paragraph 16. The Reserve Bank overlooks also that public opinion, however strong, is not an appropriate substitute for the rule of law and is in fact an undesirable and dangerous measure for what is in the interests of justice. In addition to these, the Reserve Bank overlooks another crucial inquiry in the determination of whether or not the public protector has breached her constitutional duties, and it is this. The Constitution in Section 182(1) confers upon the public protector the power to investigate conduct, to report on that conduct, and to take appropriate remedial action. There is no suggestion that the public protector did not investigate the conduct complained of by an experienced senior counsel. There is no suggestion that she did not report on that investigation and of that conduct, as the report itself attests. There is no dispute that her remedial action was inappropriate, because she's not attacking the order in respect of the setting aside of a remedial action. So there's no dispute about the inappropriateness of the remedial order, of the remedial action. But does taking inappropriate remedial action constitute a breach of a constitutional power? One can answer that question by way of a rhetorical question in relation to judges. The Constitution or courts enjoin judges by Section 165(2) of the Constitution to act independently and apply the law impartially and without fear, favor, or prejudice. Now, does a judge who makes a ruling on the wrong legal principle thereby fail to apply the law impartially? If the answer to that question is no, then why should it be yes in respect of the public protector? This court has fortunately taken us out of our misery in respect of that very question in Basson 2. In that case, the state raised a litany of complaints against a trial judge accusing him of bias because he, quote unquote, erred consistently and dramatically in favor of the accused. Now, among the examples mentioned are the following. First, that the trial judge admitted evidence taken on commission in the United States without permitting the accused to respond to that evidence. Two, that the trial judge permitted 2 state counsel to cross-examine the accused. 3, that the trial judge, quote unquote, misunderstood much of the evidence presented, which led him to make erroneous factual findings that were prejudicial to the state and exculpatory of the accused. They also complained that the trial judge accepted implausible evidence from Dr. Basson which was contradictory and not supported by the record. They complained that the trial judge dismissed an objection on the ground that an attorney-client privilege attaches to the attorney and not to the client. This court accepted that these were misdirections by the trial judge, but did it find that this was evidence of bias or failure to apply the law impartially without fear, favor, or prejudice? No. It said, and I'll only mention three things. This court said, one, in respect of the second category of complaints, it is clear that at least one of the trial judge's interlocutory rulings was based on wrong legal principles, and we accept that in many of the examples referred to by the state, another court might have reached a different conclusion on the facts. Two, some aspects of the evidence of the respondent appear somewhat improbable to us. And three, the fact that a trial judge may make an interlocutory ruling mistakenly does not provide weighty material to support a conclusion of bias, nor does the judge's refusal to exercise his discretion to call further witnesses. This is what this court says in Basson 2 at paragraphs 100 to 101. The public protector took inappropriate remedial action. She made a mistake. Or to put it strongly, she misdirected herself in law. Why should that be the cause for a finding of bias against her when it is not in respect of a High Court judge? The public protector had a meeting with the presidency and the State Security Agency at her offices without the presence of the Reserve Bank. She also had two separate meetings with the Reserve Bank without the presence of the presidency and the State Security Agency. Now, why should that be evidence of bias when this court found that admitting evidence on commission without affording the accused the opportunity to respond to that evidence does not amount to bias? The vulnerability aspect discussed in the meeting with the State Security Agency related to Judge Heath's media statement concerning a run on the banks. The substance of the report and the final remedial action was not discussed at all. We submit with respect that there is no merit in the charge that the public protector breached her constitutional obligations. But the declaratory order was not properly brought. It was raised for the first time in replying papers. It is inadmissible to raise a new issue in replying papers for the first time. We know that this is not a hard and fast rule, as the Supreme Court of Appeal tells us in Mostert versus First Rand Bank. But there are no exceptional circumstances in this case. The Reserve Bank knew when it filed its review application about what it terms undocumented meetings, and from these, it drew inferences unfavorable to the public protector. It should have sought a declaratory order at that stage, as that would have afforded the public protector an opportunity to deal with it under oath, not in heads of argument. As it happens, and this is important, well, it's as important as every other submission we've made thus far. As it happens, the reply had been deposed on the 27th of November 2017, and argument was scheduled for the following Tuesday and Wednesday, at which the public protector had to resist not just the Reserve Bank's review application, but two other applications by ABSA and the National Treasury. We are instructed that all three applicants insisted on the matter being argued on those days, and that was the 4th or the 5th and the 6th of December of 2017. The explanation is given in full and appears at volume 10 of the record at pages 785 to 792. The public protector was not in a position to file further affidavits in response to the replying affidavit because the other side was doggedly opposed any postponement. And we are instructed that there wasn't much sympathy from the bench either in that specific regard. Now, the public protector never had an opportunity to deal with what is in fact an existential prayer. As we know from EFF versus the Speaker, a finding that a constitutional being has failed in her constitutional obligations sounds a death knell to any prospects of remaining in office. With such an outcome in prospect, a prayer such as this cannot fairly be introduced for the first time a week before argument, especially when the Reserve Bank knew all along that this was its intention. Appropriate relief in this respect, we submit, should be to remit the matter to the High Court so that it can be dealt with fully and comprehensively under oath, or by this court after a full ventilation under oath. In any event, this court has reaffirmed in Tasima the principle that a court is not free to grant relief that has not been sought. At least in the Sasa versus Minister of Social Development case, the minister had been called upon to show cause why personal cost orders should not be made against her. None of that in this case. Now, those are our submissions in respect of the declaratory order. As regards the personal cost issue, again, the Reserve Bank ambushed the public protector with this prayer in its replying affidavit. It is an unprecedented prayer, as never before has such a cost order been sought against a public protector or any Chapter 9 institution as far as we know, or head of a Chapter 9 institution. That alone should have prevailed on the High Court to adopt the same approach that it did in respect of the declaratory order. The justices will recall that the court refused to grant a declaratory order because it was raised for the first time in reply. We say it should have adopted the same approach in respect of the cost issue, personal cost issue. The public protector was not afforded that opportunity. This was sprung on her a week before the hearing of argument in 3 applications by 3 different applicants with 3 different sets of counsel. She had only one set of counsel who had 2 days to draft an answering affidavit and settle it, in 3 applications, 2 days to draft heads of argument in 3 applications, and over a week to go through an entire record of 3 applications before arguing the matter on the 5th and the 6th of December. An explanation of this, I urge the court to go to the record, volume 10, pages 785 to 792. In any event, the personal and punitive cost order against the public protector is both undesirable. In fact, against this public protector and any other head of a Chapter 9 institution is undesirable and inappropriate in the circumstances of this case. Making decisions founded on incorrect appreciation of the law or legal principles does not establish bias or bad faith, as this court tells us in Person 2. It does not establish incompetence either. Many High Court judges in the SCA get the law wrong from time to time and are set right by this court. No one is suggesting that they are incompetent or that they've breached their Section 165(2) constitutional duty. Why should that be so in respect of the public protector or any head of a Chapter 9 institution? Failing to observe Audu principle does not by itself justify an inference of bias, as the Supreme Court of Appeal tells us in the competition case. So when the public protector met with the presidency and did not subsequently meet with the Reserve Bank on what was discussed, she was not being biased against the Reserve Bank. Committing procedural irregularities in an investigation is not to act in bad faith. There are remedies in law for that, including a review application, which has proved effective in this case. The public protector did not act unreasonably in opposing 3 applications, as I said at the beginning, in light of the fact that both Judge Heath and Judge Davis, independently of each other, concluded that the lifeboat transaction was unlawful. The Public Protector did not discuss the final report. So the High Court order has now given impetus, and this is the danger of this, it has now given impetus to cost orders being sought against the pension fund's adjudicator in applications brought against her for setting aside of her determinations. I know because I'm involved in such cases. It will not be long before the same personal cost orders are sought against the Vice Ombud for calling out Ponzi schemes. Next, personal orders may be sought against the Auditor General.
The 20 minutes is up.
Yes, I'm almost finished, Chief Justice. I have just one issue. Personal orders may well be sought against the Auditor General now that he has been given teeth to hold errant organs of state accountable when reviews are sought against his reports. So on this cost issue, we also submit with respect that the matter should either be remitted to the High Court so that it can be fully ventilated under oath, or this court issue directions about the filing of papers, and then it can be argued fully before this court after being dealt with on affidavit. Thank you, Chief Justice.
You may proceed to other matters, or are you now done and you're waiting just for our questions?
Yes, Chief Justice.
Very well. Colleagues?
Mr. Ngalwana, why should this court grant direct access when, in this case, the applicant is in fact seeking, it appears that she seeks leave to appeal against an order of the High Court? Why do you want us to even consider the question of direct access?
Well, thank you. Justice Mhlahla, as you'll no doubt be aware, that the requirement for direct access is what is in the interest of justice, among other things. In this case, there is an ever-present danger of the public protector or any Chapter 9 institution being mulled in personal and punitive court orders until this court has spoken. People are not going to wait until the matter has gone through the Supreme Court of Appeal and then come to this court to bring applications of this nature. In fact, there have been 2 applications already that have been heard by the High Court in Pretoria seeking personal court order against this public protector.
No, I think my sister was saying, why don't you stay with an application for leave to appeal rather than bring a direct access application?
Well, thank you, Chief Justice. As will have been noted in our application, we make this in the alternative. We bring the direct access, and so that if the court finds that the case has not been made out for direct access, we then seek the leave to appeal application. But if we can get our foot in on either ground, we are happy.
Thank you, Mr. Ngalwana.
Is that all?
You want more?
No. Thank you, Chief Justice. Thank you, Justices.
Ms. Hofmeyer, the understanding is that you will also have 20 minutes without interruption.
Thank you, Chief Justice. I'm worried that might limit the questions unduly, but
Well,
I'm happy to take the 20 minutes.
Well, it's up to you. Do you want questions or do you want the 20 minutes?
Chief Justice, my only request is to be able to sketch the factual background of the case. Once I've completed that, I'm more than happy to take questions from the court.
Just indicate to us when you're ready.
Indeed.
Otherwise, I'll wait until the expiry of 20 minutes.
Thank you, Chief Justice.
Thank you.
My proposal for the submissions today from the Reserve Bank is to address 4 topics. The first will be to set the factual background to the case. The second will be to address the question of the personal costs order against the public protector and why it should not be overturned on appeal before this court. The third aspect will be to address the declarator and why it ought to have been granted by the High Court. And then finally, to address the question of costs in this court. My learned friend began his submissions with a question. The question was whether the country could afford to have the head of a Chapter 9 institution be mulcted in punitive costs where she was only performing her constitutional obligations. The answer to that question is clearly no. That would never be something the country should afford, nor is it something that the Constitution countenances. But this is not that case. This is a case in which the public protector flagrantly disregarded the obligations on her office. This is not a case about an error of law or an error of fact or a mistake or a misdirection. It is a case about a public protector who failed to give a frank and candid account, as she is required to do before a court when her conduct is impugned. And the facts of this case bear that out. We submit the facts are the beginning and the end of this matter, and my learned friend's argument has with respect eloquently navigated around those facts. It has failed to confront them. It must confront them because those facts are stark, they are revealing, and in our submission they justify both orders that were sought by the Reserve Bank before the High Court. So what are those facts? Well, the facts begin on the 20th of December 2016. On that day, the Public Protector issued her provisional report, and she sought comment from affected parties. It is essential to consider what that provisional report provided as its remedial action. It provided, in paragraph 8.3 of the report, that the President should consider whether it is necessary to appoint a commission of inquiry to investigate alleged apartheid corruption. And it went on and said if the President finds that that is in the public interest, then the Commission should investigate those matters. What the provisional report did not do is direct the President to establish a commission of inquiry. In that respect, it was different to the State of Capture report, which had recently been released by the current Public Protector's predecessor, in which the issue that subsequently became the subject matter of litigation was whether the Public Protector could direct the appointment of a commission of inquiry. On the 20th of December, the Public Protector had already catered for that debate in her provisional report. She had not directed the President. She had asked him to consider whether to appoint a commission of inquiry. The next event is on the 28th of February 2017. On that day, the affected parties responded to the provisional report. The Presidency responded. The Presidency responded in a 2-page submission, and it has great significance in this case. It appears at volume 6, page 476. It is 2 pages. It says the following in summary. It notes the contents of the provisional report. It records that the President is not bound in law to accept the advice of a commission of inquiry, and it thanks the Public Protector for the opportunity to comment on the provisional report. What that letter does not do is request a further meeting with the Public Protector to discuss the provisional report. That is of great significance because the Public Protector will later on oath say that this letter said that, and it did not. After the written submissions were received on the provisional report, there was one further follow-up from the Reserve Bank. The Reserve Bank submissions on the provisional report had exposed legal errors in the provisional report, had been concerned about the process that had been followed and the jurisdiction of the Public Protector to pursue the investigation, and it had also signalled that one aspect of the remedial action in the provisional report was likely to have dire consequences for the financial stability of the country. What the provisional report had envisaged in addition to the appointment, if the President deemed it appropriate, of a commission of inquiry, was that one of the central functions of the Reserve Bank would no longer be available to it. That is its role as lender of last resort in situations where there is financial instability in the banking sector. The provisional report contemplated remedial action that would take that power away from the Reserve Bank. And so on the 7th of April, when the Reserve Bank had not heard anything in response to its submissions, it wrote to the Public Protector and it said again, there could be serious financial implications if the type of remedial action that you were anticipating in your provisional report finds its way into the final report. And so it called on the Public Protector to give it warning if her final report was likely to have similar type of remedies in it, so that it could take steps to protect the position of the financial markets. There was no response to that letter and no further opportunity afforded to the Reserve Bank to engage with the Public Protector. Instead, the Public Protector had a series of meetings with other parties in circumstances that we submit are highly questionable. The first of those occurred on the 23rd of April 2017, where she met with Mr. Goodson. Now, the Reserve Bank was never asked for its comment on Mr. Goodson's views. What it would have said, and it did eventually say in its supplementary founding affidavit after the meeting with Mr. Goodson was made clear, was that he was a former director and shareholder of the Reserve Bank who had been found to have acted in conflict of interest in relation to the Reserve Bank and in breach of his fiduciary duties, and further that his theories about the nationalization of state currencies and state bank creation was maverick, ill-informed, and contrary to sound monetary policy. It was not given an opportunity to make that known about Mr. Goodson and the type of advice that he was giving to the Public Protector. The second event was a meeting with the Presidency on the 25th of April 2017. As I engage with the meetings with the Presidency, I have to do something of an act of gymnastics, because the Public Protector's account of these meetings has changed repeatedly in the series of affidavits that she has filed, first in the High Court and then in this court. But I would caution this court first and foremost to approach this appeal on the basis of the case that was before the High Court, because it is the High Court whose order on personal costs is appealed to this court, and so the question before this court on whether to overturn that order on appeal is the high bar, because it is a true discretion on costs that is exercised by the High Court. What the Public Protector must show to be successful in appeal against that order is that there was a misdirection on the part of the High Court, and the High Court only had before it the facts that were at that stage disclosed by the Public Protector. So let's begin with the 25th of April meeting with the Presidency. That meeting, said the Public Protector in her affidavits before the High Court, was a meeting at which, and I quote, "From the discussion at the meeting, I became concerned that my draft remedial action to direct the President to establish a commission of inquiry may face the difficulties faced in the state of capture report." That is false, for the reasons that I've already traversed. The provisional report did not direct a commission of inquiry to be established.
Chief Justice, may I ask Ms. Offmer just to give us a page reference?
Indeed. That is at volume 3, page 199, paragraph 173. That is the only explanation that was proffered in the High Court for the meetings with the Presidency. The first thing that is noteworthy about that explanation is that it related to a meeting previously undisclosed with the Presidency. The meeting with the Presidency that was disclosed in the record is a meeting on the 7th of June, which I will come to. But this meeting was never disclosed in the record. It was put up for the first time in the answering affidavit, And the claim that was made about it was that it was from that discussion that the public protector became concerned that her provisional report's remedial action would suffer the same criticism as the state of capture report's remedial action. We submit that that is false. It is false when consideration is given simply to paragraph 8.3 of the provisional report. The other noteworthy aspect of that meeting with the presidency is that it was not disclosed in the report at all, nor indeed was there a transcript of that meeting, nor recording of it. The next meeting was on the 3rd of May, and that was with the State Security Agency. Again, no recording of the meeting, no transcript. And before the High Court, what the public protector said about that meeting was that it was a follow-up meeting with the signatory of the SIEX report, which was the subject matter of her investigation, and it was a follow-up on implementation of that report. What the public protector did not deal with in the affidavits before the High Court was the concerning note that was taken of that meeting, in which the vulnerability of the Reserve Bank was discussed with the State Security Agency. Not a word of explanation was presented to the High Court as to why that topic could possibly have been the proper subject matter of an engagement with the State Security Agency. And then we have the meeting with the presidency on the 7th of June, 2017. That meeting was not addressed at all before the High Court. That meeting has 8 pages of handwritten notes that were produced after it, and which were furnished in the Rule 53 record. But they are notes that raised serious concerns about the conduct of the investigation. And the reason for that is that the notes disclose that the public protector was discussing the final remedial action with the presidency. There can be no doubt that that is what she was discussing if we take a moment to look at those handwritten notes. They are in volume 2, and they commence at page 130 of volume 2. What appears at page 130 is a handwritten note of the 7th of June meeting with the presidency's legal advisors. That first page shows that the discussion traversed what became the remedial action in the final report. It's undeniable on its face. What they discussed was the SIU reopening through an amendment to include a further investigation into that which had previously been investigated by Judge Heath. That, you will recall, is one aspect of the final remedial action. It directs the SIU to approach the President to amend the now 17-year-old, I think it was at the time of the High Court, proclamation that had required an investigation originally into the Absa lifeboat and to extend its terms of reference. That is what was discussed at the meeting with the presidency, as is clear from the first page of the notes. The other thing that caused the Reserve Bank great concern when these notes appeared in the record was that the conversation did not end there. It moved on to the question of changing the Constitution insofar as the Reserve Bank's central powers are concerned. That appears at page 134 of volume 2. In its supplementary founding affidavit, the Reserve Bank questioned how these topics could possibly be the appropriate subject matter for an engagement with the presidency, for which there was no transcript of the meeting, and at a time when no similar engagement had been afforded to the parties most affected by that remedial action, such as the Reserve Bank, a contemplated change to the Constitution to strip it of its central function would no doubt have been a matter on which it should have been heard. But in the High Court, all that was offered by the Public Protector was an explanation of a meeting on the 26th of April and no engagement with the substance of what was reflected in the notes of the meeting of the 7th of June. In this court, the Public Protector has sought to explain those deficiencies before the High Court. We submit first that that attempt at explanation ought not to be taken into account by this court, because the question before this court on appeal is whether to overturn the High Court's order based on the facts before it. But if this court goes to that explanation, we submit it compounds the case against the Public Protector, and in due course I will argue for why it justifies a costs order against her in this court in her personal capacity. The first thing that the Public Protector has said in this court in her affidavits about the 7th of June meeting, well, let me go back a step. In this court, the 25 April meeting is explained as an error. She'd confused the 25th of April with the 7th of June. The 25th of April was simply a meet and greet. And she puts up further email exchanges to confirm that before this court. So she says the substance of the engagement with the presidency occurred on the 7th of June. But the first thing that is said in the affidavits before this court is that that meeting was requested by the presidency in response to the provisional report. And the reference for that is the 2 pages that I took the court to previously. Those 2 pages, which on their face request no such meeting. And yet the Public Protector, under oath in this court, says that is why she held the meeting on the 7th of June, because the President requested it in his response to the provisional report. When that patent error was exposed in the answering affidavit of the Reserve Bank before this court, the Public Protector took steps to file a replying affidavit. That is not catered for in the rules, but she saw it clearly necessary to do so. And the explanation she gives there is that we're correct, in essence. It wasn't requested in the response of the presidency to the provisional report, and she seeks to explain the error on the basis of a numbering discrepancy. She says she referred to Annexure PP 8 in the High Court when she meant to refer to Annexure PP 9. Well, unfortunately, that makes the situation worse. Because Annexure PP 9 to the affidavit in the High Court is the invitation to the meet and greet on the 25th of April. As matters stand before this court, there is no frank explanation from the Public Protector of why that meeting on the 7th of June was convened with the presidency. Her attempts to explain them are on their face false. The further thing that occurs in the affidavits before this court in relation to that meeting is that the Public Protector provides contradictory accounts of its subject matter. In her replying affidavit, from this is volume 10, page 776, starting at paragraph 10.3, the Public Protector is at pains to explain that that meeting had nothing to do with the remedial action of her final report. She says what was discussed was the content of the presidency's response to the provisional report and that the final remedial action was not discussed. That is at paragraph 10.7. But later, in that very same replying affidavit, the Public Protector confirms that those 8 pages of notes that found their way into the Rule 53 record are a record of what was discussed at the meeting. She is joined in that submission with confirmatory affidavits from the other members of her office who joined her at that meeting. As I have already traversed for the court, those notes show squarely that the remedial action of the final report was discussed at the meeting with the presidency. What was discussed with the presidency on the 7th of June, 2017, became 12 days later the remedial action of the final report. The final report was issued on the 19th of June. It directed Parliament to amend the Constitution to take away the Reserve Bank's central function and to make it a vehicle for socio-economic transformation. It directed the SIU to approach the President to amend the proclamation which had existed 17 years previously and which had been the basis of the investigation into the then Absa lifeboat. The issue of the report on that date had an immediate and negative impact on the economy, precisely the conduct that the Reserve Bank warned against and sought an opportunity to engage the public protector on. The papers disclosed that the Rand lost 2.02% overnight, 1.3 billion Rand of South African government bonds were sold by non-residents, and ratings agencies threatened further downgrades because they saw the amendment to the Constitution to strip the Reserve Bank of its central function with grave concern. Those were the facts that we submit set the backdrop to this case.
The 20 minutes is up.
Thank you, Chief Justice. If I may proceed with the argument and, of course, invite questions at any point.
I'll take up your invitation, Ms. Hofmeyer.
Justice Theron, thank you.
The High Court, in its judgment at various passages, for example, paragraph 120, page 612, volume 8, makes certain statements about the public protector and her actions. Says, the public protector did not conduct herself in a manner which should be expected from a person occupying the office of the public protector. Further statements are made in that paragraph. And if one looks later at paragraph 127, page 616, says, in the matter before us, it transpired that the public protector does not fully understand her constitutional duty. Does the High Court anywhere find that the public protector acted in bad faith?
The High Court finds numerous failings on the part of the public protector. They find her to have been secretive. They find her to have been disingenuous.
Yes, I know that. And they find that she fails to adequately disclose. It makes various other statements. But
Yes.
does it make a finding that she acted in bad faith? It speaks about the good faith and the protection that she gets from that.
Tehran, our answer is yes, they do. They find it without using those two words. They find it with equivalent findings against her. Secretiveness from an organ of state that is required to be transparent and open is an indication of bad faith in the conduct of her investigations. A finding that she's disingenuous in her explanations.
But where in the judgment does that say so? That the failure to disclose, the failure to understand her duty equates to bad faith?
Justice Tehran, if I may, I will come to that answer, but I would like to just address the emphasis that is placed on bad faith. My learned friends in their argument make a great deal of it because of the recent judgments from this court in the Black Sash matter, where the test in that case for punitive costs was signified as bad faith or gross negligence. But in the very paragraph in which this court set that test, we submit it is important to read the full sentence in which it did so. It said the following about personal costs orders against public functionaries. It said they are there to vindicate the Constitution and that they may be granted, for example, when public functionaries act in bad faith or with gross negligence. We submit those words, for example, are critically important in the approach to the law around this issue. Costs are a matter of true discretion on the part of the court. It is not an exercise of power on the part of the court that is subject to a limited or closed list of circumstances. We submit before this court that when in black sash those two indicators of the appropriate circumstances for a personal costs order against a public functionary were provided, they were provided principally as illustrative of the circumstances in which such an order can be granted. So our first submission in response to your questions, Justice Turon, is not with respect to place undue emphasis on bad faith. It is an indicator of the type of conduct that would merit a personal costs order. But we submit the underlying question is whether the conduct of the public official is such that it deserves censure. Because without that censure, the Constitution is not vindicated. In this case, the conduct of the public protector before the High Court was evasive, was secretive, was disingenuous, and was a pretense, according to the High Court. We submit none of that conduct is consistent with an appropriate approach by the public protector, either to her investigation or we submit to her obligations to the court. Once the litigation was initiated, as an organ of state, she had heightened duties. She was required to be frank and candid, and at no point in her affidavit before the High Court did she meet that standard. And so we submit in conclusion, you will not find the words bad faith, but we submit that does not mean that the order should be overturned on appeal.
Well, I'm sorry to interrupt. Perhaps you can look at paragraph 128.
128. Justice Froneman, I fear as I turn there. Yes, indeed. Justice Froneman, I'm aided by your direction to paragraph 128. My short submission is that the words bad faith do not appear, but what was clearly the finding of the High Court was that she had not acted in good faith, which was the requirement for the indemnification on which she relied under the Public Protector Act. In those circumstances, there is no doubt that the High Court found that she did not have available to herself the indemnification under the Act because she did not act in good faith, but she did act in a manner that is not becoming, we submit, of the high office and the important place that it occupies in our constitutional scheme. My learned friend attacks the personal costs order against the public protector that was granted by the High Court on the basis of we submit a technical argument. He says it was not sought in the notice of motion. Just as you will have seen from our heads of argument, we have provided ample authority for the proposition that punitive or other costs orders are not required to be sought in the form ultimately sought in a notice of motion. Though, provided there is notice, it can come as late as in the heads of argument of the party seeking either punitive or personal costs. And so we submit there is no merit in that submission. We submit, moreover, that the facts before the High Court warranted the personal costs against the public protector. But we go further. The Reserve Bank seeks conditionally leave to appeal against the High Court's refusal of the declarator that it sought. Before I address the declarator, there are two aspects in relation to my learned friend's argument that I must address at the outset, because there appears to be a confusion between the Public Protector and the Reserve Bank as to the legal basis for that declarator. My learned friend took the court to section 182 sub 1 of the Constitution. That is the section which deals with the functions of the Public Protector. And his submission was that you could never grant a declarator when what the Public Protector was doing was merely exercising her duties under 1821 of the Constitution. In that respect, we agree with him. But that was not the section that was invoked by the Reserve Bank for the declarator that the Public Protector had abused her office in the course of her investigation. The section upon which reliance was placed is section 1812. That is the section of the Constitution that requires the Public Protector, as other Chapter 9 institutions are required, to be independent, to be subject only to the Constitution and the law, and to be impartial and to exercise their powers and perform their functions without fear, favour, and prejudice. It was that section of the Constitution that the Reserve Bank submitted had been breached by the Public Protector. The second respect in which my learned friend's characterization of the declarator is with respect wrong is his submission that the declarator ought not to be granted when all that the functionary is accused of is applying the wrong legal principle, or having made a mistake, or having misdirected herself on the law. Indeed, again, we agree with my learned friend, that would not be the basis for a declarator that an abuse of office has occurred. Innocent errors, mistakes, errors of law, errors of fact are the proper subject matter of stock standard reviews. What the Reserve Bank submits about the conduct in this case is that it violated another section of the Constitution, section 1812. And that is a section that requires the Public Protector to be impartial and independent in the conduct of her investigations. And what is clear from the 28th of February 2017 to the 19th of June 2017 is that the Public Protector did not hold good to that duty. The Public Protector had secret meetings with the Presidency. The Public Protector has never adequately explained those meetings. They are meetings at which the subject matter traversed topics that ought never to have been traversed with the Presidency. The Public Protector did not disclose those meetings in her report. Her attempts before this court to explain that away, we submit, are inadequate. Her attempt, in fact, placed reliance on that two-page letter. The Public Protector said she didn't need to disclose it in the report because it was already disclosed in the President's response to her provisional report. Well, that is false. She is an organ of state required to be transparent, and she failed, we submit, in an egregious manner in meeting that obligation.
Ms. Mayor,
Yes,
the
Justice
High
Mahlangu.
Court refused to grant this order because it was raised for the first time in the replying affidavit.
If I may address that.
Yes.
In order to do so, reference must be made, we submit, to the supplementary founding affidavit of the Reserve Bank in the High Court. That appears at volume 2. The charge, and the charge that ultimately persuaded the High Court, was that this declarator could not be granted because it was sought for the first time in reply. We submit that that was an error. It was not sought, and the importance I'm going to place is on the next few words, for the first time in reply. And the reason for that is because the supplementary founding affidavit squarely engaged the question of the breach of Section 181 of the Constitution. But it did so cautiously, and so the background to the supplementary founding affidavit ought to be understood in the context of the litigation. At the time that the Reserve Bank filed its supplementary founding affidavit, it had received a Rule 53 record that was haphazardly put together, had no discernible index, and in which, amongst thousands of other pages, there were handwritten notes of a meeting with the presidency on the 7th of June and a meeting with the State Security Agency on the 3rd of May. They weren't indexed. There was no way to know, for example, whether those 8 pages of the meeting were in fact all from the same meeting. But if they were, the Reserve Bank, in its supplementary founding affidavit, raised the question of the impartiality and the independence with which the Public Protector had conducted her investigation. That you will find in Volume 2 at page 101. It begins over the previous page at 100, where the concluding submissions are made by the Reserve Bank in relation to those 8 pages of handwritten notes. What the Reserve Bank says at paragraph 27 is that if the subject matter of the meeting with the presidency covered all 8 pages, then it was highly irregular. The meeting traversed the Public Protector's proposed remedial action to amend the Constitution, to deprive the Reserve Bank of its role in protecting the value of the currency. It went on and said that is an aspect of the remedial action that had nothing whatever to do with the presidency. And it goes on at the end of that paragraph to say the Public Protector is required under Section 181 of the Constitution to conduct her investigations independently and impartially. Discussing these aspects of the report with the presidency destroys that independence. The point about Section 181 was taken squarely in the supplementary founding affidavit. But the Reserve Bank did not stop there. It made clear precisely what it was calling on the Public Protector to answer. And that appears over the 2 pages. Well, it begins, in fact, at page 102. At paragraph 35, the Reserve Bank concludes on the following basis. It says these are serious accusations to make against the Public Protector. Those are the accusations that she has conducted the investigation in defiance of the requirement that she act impartially and independently. The deponent says, I do not make them lightly. I've been hampered in my ability to understand the documents in the record because they have yet to be properly identified by the Public Protector. I've therefore proceeded cautiously in this section of the affidavit to explain what the documents appear to show. And then the deponent goes on. Given the seriousness of these allegations, I respectfully call on the Public Protector to deal with each and every averment set out above when she files her answering affidavit. And it went on to ask her for a full account of why there was no recording made of that meeting. Justice McClantla, our short answer, therefore, to the technical objection that ultimately persuaded the High Court is that it was an erroneous decision of the High Court not to grant the declarator. Because as matters stand, the supplementary founding affidavit clearly invoked Section 181, proceeded cautiously because the Reserve Bank did not want to jump to a conclusion as serious as the one that it ultimately was vindicated, we submit, in making, that the investigation had been conducted in a partial and not independent manner. It was finally when the answering affidavit was produced and none of these serious matters were engaged with that the Reserve Bank made plain that it would seek the declarator, that there had been an abuse of office. And it would seek, in addition, personal costs against the Public Protector.
Advocate Hofmeyer?
Yes, indeed, Justice Goliath.
I'm concerned about the issue of prejudice to the Public Protector because the issue of the punitive cost order was only raised in the replying papers. Do you contend that there was no prejudice in that regard? Or if there was any, could it have been averted in any way?
Thank you, Justice. Our short submission is no, there was not prejudice, and that's for two reasons. The one is actually an argument that my learned friends traverse in their heads of argument. They make plain that all the facts that underpinned the personal costs order against the public protector were ventilated already in the founding affidavits of the Reserve Bank. The question of prejudice is whether there has been an opportunity not granted to a party to address the facts which ultimately justify the personal costs order. We submit that was not the case here. Those facts were ventilated in the founding affidavit and in the supplementary founding affidavit. And so the public protector had an opportunity to answer the case against her, where those facts were relevant ultimately to the personal costs order. But the second point is the point I made earlier in relation to the law on this question. It is not a requirement that costs orders, either in their quality or against whom, must be ventilated either in the notice of motion or indeed specifically called for in the papers. The cases show that it can be sought, provided it's supported on the facts before the court, even at the stage of heads of argument. And so we submit that is an unwarranted technical approach to take to the costs order that was granted in the High Court.
But is that legal submission of yours in keeping with the very cautious approach that this court has taken in regard to personal costs orders, where people were joined in their personal capacity before it was done and given a further opportunity?
Justice Froneman, we say it is consistent because there's a clear distinction in this court's jurisprudence between its recent remedies and orders in relation to personal costs and its earlier ones. And if I may just have a moment to explain that submission. In Black Sash, which is the most recent judgment from this court in relation to personal costs orders, the issue that arose there was that it was the court mero motu questioning whether there oughtn't to be personal costs against the minister. It was because the court raised the question mero motu that it was necessary then to make provision for joinder of the minister and to seek submissions on it. That, we submit, should be distinguished from the previous jurisprudence of this court and others, where the personal cost order is sought by the litigating parties before the court. It has never been a requirement in those circumstances for the individual against whom the personal costs order is sought by one of the litigating parties to join that individual personally and then to have further submissions from that person. And so we submit that it is entirely consistent, provided that distinction in this court's jurisprudence is borne out. The final submission, and I see that we are close to 11:15. I do simply have one final submission on costs in this court. Chief Justice, with your leave, I'm happy to continue. The Reserve Bank seeks costs in this court against the public protector in her personal capacity. It does so for two reasons. The first is that it submits that this appeal had no prospects of success from inception. It had no prospects of success from its inception because of the high standard applied by an appeal court to overturn a costs order of a lower court. That is a standard of misdirection, and on the basis of the facts that were before the High Court, there were no prospects that that order would be overturned. The second submission we make for why costs ought to be ordered against the public protector in her personal capacity in this court is because of what the public protector has gone on oath and said before this court. The public protector could have left the facts as they were in the High Court and simply sought to navigate this appeal on the basis of those facts. She elected not to do so. We submit because those facts were stacked up so heavily against her. And so instead, she deposed to 3 affidavits in this court, seeking to explain what had been presented to the High Court. But in so doing, we submit she has not treated this court with the dignity and respect that it deserves, because those affidavits continue to compound the case against her. They continue to repeat falsehoods. Even in the attempt to explain away the falsehoods, they peddle further falsehoods. We submit that that conduct is egregious. It is conduct that merits censure from this court. It is conduct that is in breach of what this court has said on many occasions is the heightened obligation of organ of states in litigation. They must be forthright, they must be frank, and they must be candid. No part of the affidavits before this court from the public protector meets that standard. And so we submit this is an appropriate case in which costs ought to be ordered against the public protector in her personal capacity in this court. And so to conclude in relation to the relief sought by the Reserve Bank, first and foremost, the Reserve Bank submits that the application for leave to appeal by the public protector should be dismissed. If that is to be the result of the court, then the Reserve Bank's conditional cross-appeal would also fall away. It has only pursued the declarator that was not granted in the High Court before this court conditionally. If this court were to grant the public protector leave, then we submit it should grant leave both to the public protector and to the Reserve Bank. It should dismiss the public protector's appeal. It should grant the Reserve Bank's appeal and declare that the public protector abused her office during the investigation that led to the report. That order we submit is not only required by the Constitution, because Section 181 has been breached, but it is an order which has great value in our constitutional democracy. In Rail Commuters, judgment of this court, Justice O'Regan made the point that the utility of declaratory orders by the courts is that they declare what the law is and leave to the other branches of the state to do that which is required of them in relation to that declarator. We submit that this is an equivalent case. It is a case where it is incumbent upon this court to declare conduct that is inconsistent with the Constitution to be such, and to leave it to the other branches of the state to take action should they deem it appropriate in relation to that abuse. Finally, we submit that costs in this court should be paid by the public protector personally.
Well,
those are our yes,
well, help me to understand. Advocate Paul Hoffman, SC, refer a matter to the public protector to understand what happened to certain resources, some 1.3 billion that was advanced by the Reserve Bank to Bankorp, I think it was.
Yes.
That seems to have dissipated. The focus now is more on how the public protector pursued what appeared to have been something that generated some public outrage. So that is buried and dusted. It's like nothing has happened. The CX report, all these negative things are pushed aside. The primary focus now is on how she went about trying to get to the bottom of what apparently had gone wrong. So just help me to understand these things so that in my private space I can understand what's going on here. Was the money paid?
Chief Justice, if I may address your concern that
No.
things have been pushed aside.
Yeah, no, it's okay. We'll get back to that. Was the money paid back?
Yes, indeed it was.
And that information was available to the public protector?
It was indeed. And it was the subject matter of 2 further inquiries.
No. Let me just make a note of that. So Bankorp, is it Bankorp?
It was originally Bankorp, and then it was taken over by ABSA.
I know, so is it Bankorp that paid or is it ABSA?
They both paid over a successive series of agreements.
Yes. So when who began the investigation, was the money already paid? Was
Yes,
it
indeed it
Judge
was.
Heath, Judge Davis? When was the money paid? At the time when only the public protector investigated, or the two judges?
No, even before the two judges.
Okay. Where do I find that?
Chief Justice, you will find it in the Reserve Bank submissions, both in relation to the provisional report and in the affidavits of the Reserve Bank.
Yes. What
You would
pages?
also find it, in fact, in more detail
Yes.
in the answering affidavit of ABSA in the High Court, but that is not before you, because the case before this court is a very limited case.
I know. I just want to clear this in my
Indeed.
own mind. Which
Indeed.
pages should I look at?
I'll ask my learned junior to assist me with a reference, which I'll give you in a moment.
Yes.
But I would simply like to make the point that the notion that the ABSA lifeboat was pushed aside
Yes.
is, with respect, not a correct one.
No,
Because-
I'm saying we're not talking about it here.
Yes, indeed
It's like
we're
the
not.
only wrong thing to discuss, or apparently wrong thing to talk about,
Yes.
is how the public protector went about her investigation.
Yes, it is the only appropriate thing to discuss here, because it is the only aspect of the order of the High Court that the public protector sought leave to appeal against.
And context?
The indeed, context is important, Chief
Yes.
Justice.
Yes,
If I may give that context.
yes.
Before the High Court, there was a review brought by, amongst others, the Reserve Bank, ABSA, and National Treasury.
Yes.
The merits of the Public Protector's investigation and her remedial action flowing from it was fully ventilated before the High Court. That got into the detail of what had happened with the ABSA lifeboat, the fact of it, the lender of last resort assistance that had been given, the fact that it had been paid, and moreover, the two subsequent investigations, one conducted by Judge Heath
Yes.
and one mandated by the Reserve Bank itself,
Yes.
having been concluded prior,
Through Judge Davis.
indeed, through Judge Davis.
And both of them said there was an illegality involved here, did they not?
They did indeed, but
Yes.
for different reasons, did not recommend any further action being taken.
No,
in
that I
relation.
understand, but both of them said there was something unlawful about this whole transaction.
There were concerns raised about the terms on which the loan had been provided, yes. That was the subject matter of the merits of the investigation,
Yes,
and in the High Court, the review was upheld.
yes,
It was upheld because the public protector, in her investigation,
yes.
had committed errors of law, had behaved procedurally unfairly, and the High Court found there was a reasonable apprehension of bias against her.
No,
That was not appealed to this
no,
court.
that I understand. I'm just seeking to understand this. The errors committed by the public protector were committed in the course of seeking to unearth that which Judge Heath and Judge Davis said there was something unlawful about. That is correct, is it not?
Indeed, Chief
Yes.
Justice.
Okay.
And had she performed her duties independently and impartially, we would not be here today.
Sure.
We are here today because she conducted that investigation, which there may have been public concern around and public interest in a manner inconsistent with Section 1812 of the Constitution. That is the only reason we are before this court today. Good faith exercises by the public protector of her investigative powers would
Yes.
never warrant a personal costs order,
Sure.
nor would they warrant the declarator that is sought.
Now, Mr. Ngalwana submits, and tell me if he's wrong or correct, that the engagement between the public protector and the South African Reserve Bank was also not recorded. Is he correct or incorrect?
Those were two meetings that were held in 2013 and 2016.
Yes.
That fact of them not being recorded, I'm not aware of being on the papers, but we can make an inquiry in that regard.
You see, it's important that it be cleared up because he seeks to say, why is it surprising that the meeting with the president and I almost said the spooks, I don't think it's an acceptable term. Is it SSA?
State Security
State
Agency.
Security Agency. Why is it that an issue is being made out of there being no recording of the meeting between the public protector and the president, or the presidency rather, and the meeting between the public protector and SSA, whereas a similar engagement with the Reserve Bank, I don't remember whether he mentioned ABSA as well, were also not recorded.
Chief
Why
Justice-
does it not demonstrate secrecy when it relates to the other, but only as it relates to the one?
Indeed. Chief Justice, I would like to obtain an instruction in relation to the 2013 and 2016 meetings, because my record is that those precede the meetings that were held, for example, with Dr. Stultz, who was interviewed and whose meeting with the public protector was recorded and transcribed.
Yes.
My recollection is that the 2013 and 2016 meetings were initial meetings at the preparatory stage of the investigation, because remember, this conduct began, it was initiated in 2010. There was the first engagement with the Reserve Bank in 2013, and then a subsequent engagement in 2016. But I would like to take an instruction in relation to the recording, because it's not a fact that, as I have it, is ventilated on these papers.
Yes. It would help to give some perspective to Mr. Ngalwana's
Indeed.
concern.
If I may take a moment, my
Sure.
learned
Sure.
friend has something. Chief Justice, I'm loath to refer to facts that are not on the papers before this court. My instruction, though...
No. Is it now from mental recollection, or is it something that we can check and find?
You can't check and find the allegation that the 2013 and 2016 meetings were not recorded.
Okay.
Because as I have it, that averment is not in the papers before you, but it has been raised by my learned friend.
Yes.
And my instructing attorney, who was in both of those meetings with the Reserve Bank, who is sitting in this court, informs me that they were recorded.
Can
But-
we? Oh, I'm sorry.
No,
I'm sorry. Please go
I'm
ahead.
concerned to go there in the course of this argument, because they are not facts that are before you on the papers.
And if granted the opportunity, could then something be filed and those
Certainly.
Subject to them being confirmed by both parties? As a
Indeed,
court?
we can certainly do
That would help address Mr. Ngalwana's point,
Indeed.
because he shouldn't make a comparison in circumstances where the one meeting was actually recorded and the other was not.
Indeed, Chief Justice. We can
Yes.
make further submissions to the court in relation to that aspect.
Yes. Now, the disclosure of the meeting, you're basing it on what? The Public Protectors Act, or the Constitution, or common sense, or what? The
Chief
failure to disclose that there was a meeting with the President and with the SSA.
Chief Justice, just to be clear in relation to that submission, the failure to disclose was only in relation to the meetings with the presidency.
Okay.
The meeting with the State Security Agency was
disclosed.
disclosed in the
Yes.
final report.
Yes.
But the content of that discussion
Yes.
and the question of the vulnerability of the Reserve Bank
Yes.
was never addressed by the public protector.
All right.
We make that submission on the basis of the final report itself. If I
Yes,
may
no,
just
that
give you
I
a-
understand. You're saying there are matters of importance that were discussed at that meeting, that the Reserve Bank was never given the opportunity to express itself on.
Indeed, Chief Justice, but it goes further than that. It's not simply that there were engagements with the presidency about subject matter that the Reserve Bank was not heard on. It is that there were engagements with the presidency about subject matter that it was never appropriate to be discussing with the presidency. The reason for that is the following. The remedial action, which directed a change to the Constitution, is a matter for Parliament. If there was to be a mandated amendment to the Constitution, that is an act of Parliament. It is not an act that the presidency has any role to play in as head of state. Nonetheless, the Public Protector engaged the presidency about that very remedial action.
Yes, I understand your submission. I just want to grasp it properly. What is it about the engagement that shows dishonesty that ought to be sanctionable with a personal cost order? That's what I really want to understand. I don't want you to go with all these wonderful submissions that both of you are capable of making, and when I'm left to my own devices, I wish I had asked you, but you're no longer there.
Chief Justice, the problem with the engagement with the presidency are threefold. The first is that they were not disclosed in the final report.
Okay,
This
just there. Or that normally, what is the normal practice? Everything that happened is disclosed?
Indeed, because if
Okay.
you go to volume...
No, I take your word for it. So
Yes, indeed.
everything is, every engagement
Indeed.
with anybody
Indeed.
ought to be disclosed.
Well, indeed, and it was disclosed,
Okay.
well, purported to be by the Public Protector at page 878
Yes.
of the supplementary record. It
But
begins
she
at-
did not disclose this particular one.
Indeed.
That's your concern.
Indeed, the heading is 4.4.3, interviews conducted and meetings held. And then there is a list of what I take to be 12 meetings, the dates of them, and at no point was either the meeting on the 25th of April, which we've subsequently been told was a meet and greet, and on that basis would not have formed subject matter of this investigation.
Okay.
But the meeting of the 7th of June was not disclosed. That is the first evidence we submit of an inappropriate exercise of the Public Protector's powers. The second...
No. Before you go any further, is the inappropriateness of the exercise of the power about the failure to disclose the fact of the meeting taking place or the subject matter of discussion?
Chief Justice, both.
Or both?
And that brings me to the second reason.
Okay.
The first was the failure to disclose it at all. The second was the failure to engage in a frank and candid manner with the subject matter of what was discussed at that meeting. What the Public Protector has told this court is two entirely contradictory things about that meeting, and certain things that are false on their face. The Public Protector said first that the meeting was called for in response to the provisional report. That is false. The Public Protector says, at a part of her replying affidavit, that no aspect of her final remedial action was discussed at that meeting. She then later in her replying affidavit confirms that the 8 pages of notes which were made at that meeting set out what was discussed.
Yes.
And those notes show that the final remedial action was discussed.
Was in fact discussed. Just,
Indeed.
Ms. Hoffman, if you really want to be a crook, why would you even disclose those notes? If it's not a mistake, if it is not forgetfulness, why would a crooked person disclose notes that are going to show everybody that all along it's been a lie? Why?
Chief Justice, with respect, we do not submit that that is the question before this court.
No. I'm just curious. I want to understand because as I understand you saying, you see, I want to demonstrate how dishonest this Public Protector is. She was not candid. She was not frank in circumstances where her serious constitutional responsibilities requires of her to be. She said, she lied and said the president asked for the meeting. She lied and said the remedial action was not discussed. But then she shares the notes, 8 pages, handwritten, that belies her assertion. So I'm just trying to, obviously you are not in her mind, but I'm just wanting to have the benefit of your submission. Why would she expose herself like that?
Chief Justice, the requirements of Rule 53 in
Yes.
the High Court
Yes.
required all record, every piece of paper that
Sure.
formed part of the record of proceedings to be produced.
Yeah, but the crook won't do it. Which is my understanding is you're saying, this is a crook. That's why she must be made not only to pay punitive costs, but also from her own pocket. So a crook will say, no, a meeting that actually happened never happened, and therefore documentation that would demonstrate that a meeting actually happened, which he had previously said never happened, would not be shared with those who are going to find her out. She wouldn't expose herself like that.
Chief Justice, I cannot speculate.
No.
on the basis-
I'm sorry, I'm interrupting you, but I'm sure you understand. I'm just saying logically, don't speculate, pure logic, pure common sense. You know where I'm coming from, Ms. Hofmeyer? An order for costs against a state official, whether it's a judge, a public protector, or anybody, is not something that you make lightly. You don't just easily tie up the pieces and suddenly there's an order, because it could have far-reaching implications in the effective functioning of the state machinery. It shouldn't be something fashionable, you just dish it out like that. So I'm just trying to understand every aspect that is relied on for the purpose of saying, truly, this was a case for punitive costs to be paid, not even by the office of the public protector, but the public protector from her own pocket.
Chief Justice, the Reserve Bank shares your concern about the circumstances in which these orders should be granted and the limited circumstances in which they are appropriate. It was for that very reason that it proceeded with caution, as it discovered in the Rule 53 record these notes.
Yes.
And it raised queries about what they could possibly mean.
Okay,
It then called on the public protector to account.
sure.
It is not for the Reserve Bank to speculate about why those 8 pages found their way into the record.
No,
They
but
did.
but it can reason. It doesn't have to speculate, it can reason. It can be logical about it.
Indeed, and it
And
was.
that's all I'm asking for. I'm not
Indeed.
asking the Reserve Bank to speculate. Yes.
Chief Justice, when those pages appeared in the Rule 53 record, the Reserve Bank saw what they seemed to indicate,
Sure.
and it called for an account from the public protector. And on each occasion that she has sought to give that explanation, she has been found wanting.
Okay.
She has never adequately explained, we submit, why they were held, at whose behest they were held, and what they covered. And it is in those egregious and peculiar circumstances, we submit, that a personal cost order is warranted.
Okay. No. Not in good faith. But for the failure to disclose, 1, the meeting of the 7th of June, 2, what transpired in that meeting, 3, to afford the Reserve Bank the opportunity to express its views on what was going to be the final remedial action. Where else do we locate the failure to act in good faith?
There is also the public protector's treatment of the economic experts, on which she placed reliance in the answering affidavit. The High Court found that her averments under oath were a pretense. They found that her attempt to make it seem in the answering affidavit that she had relied on an economic expert, Dr. Mkhwebane, in the course of her investigation was false. They found that, as a consequence, that was a further indicator of the inappropriate manner in which she had approached the litigation. That was a fourth aspect justifying the personal costs order against her.
So it's a reliance on Dr. Mokoka and then issues around the presidency.
Indeed. If I can just refine the submission in relation to Dr. Mkhwebane, it's not the reliance per se on an economic expert.
No.
It is the reliance placed on his expertise as informing the investigation.
No, that I understand. You're saying she only consulted Dr. Mokoka after the remedial action was already taken,
Indeed.
but she made it to look like
Indeed.
her remedial action, final remedial action, was also
Yes.
informed by Dr. Mokoka's input.
Yes, indeed.
What else?
Those were the principal findings of the High Court. If I may just give you the reference to where that appears in her answering affidavit. It is in volume 3, at page 143, paragraph 2.
That's the Dr. Mokoka.
That's Dr. Mkhwebane. What the public protector there says at the outset of her answering affidavit is, where I make averments relating to economics, I do so on the basis of advice received from economic experts during the investigation of the complaint referred to below. And then she goes on in the affidavit to identify a single economic expert, Dr. Mkhwebane, to attach his report, to justify her remedial action, at times quoting verbatim from Dr. Mkhwebane's report, but then to disclose much later in the affidavit that Dr. Mkhwebane was only consulted after the review litigation had been instituted.
Yes. And you're saying that's not an error, that's a deliberate lie. Or she wanted to mislead the court.
What the High Court found is that the averment in paragraph 2 was a pretense. And we say it was a pretense in support of that finding, because what is happening in paragraph 2 of the answering affidavit is that the public protector is seeking to find support for the findings that she made and the eventual remedial action that she directed. By presenting in paragraph 2 that investigation, its findings, and the remedial action had the support of an economic expert, she is seeking to bolster the credibility of her findings. And we submit that was incorrect.
Oh, no. Is it incorrect or is it dishonest? Is it, what is the expression you used?
It is
in
a
your...
pretense.
No. There's a stronger submission, word you used earlier in your submissions.
Disingenuous?
I think it
I'm
will
trying
come.
to quote.
It will come, but I think it was much stronger than that. Yes.
Indeed.
Anyway, anything else?
It is misleading. It is a misleading averment,
Yes.
because it makes the reader think that economic experts were consulted and that they offered support for her findings, whereas a matter of fact they were not. What the public protector has come back in this court to say is that the economic expert she consulted was Dr. Goodson, Mr. Goodson.
Is that also incorrect?
She did, it appears, from the record, meet with Mr. Goodson.
Yes.
But she does not at any point seek to qualify him as an economic expert. And on the basis of what the Reserve Bank ultimately said in relation to Mr. Goodson's credentials, it would be unlikely that he could be so qualified.
Well, that is the one side of the story, isn't it?
Indeed.
Yes.
But it is not, we submit, an adequate submission from the public protector in these proceedings.
Yes.
Because her reliance is on economic experts consulted during the course of her investigation. She does not at any point say Mr. Goodson was that. She says she consulted him about matters of economics, about state banks, and the like.
But what is the meaning of that? If you say you consulted a person about matters of economics, what does it mean? Is it far removed, or is it a far removed deduction to say you consider the person to be an expert? I mean, I can't imagine anybody consulting me in matters relating to economics. Why would anybody want to consult another about matters relating to economics if they don't consider the person to be particularly knowledgeable in that area?
Indeed, Chief Justice, but the challenge for the public protector is that she never sought to qualify Mr. Goodson as an economic expert. And that is the problem with her averment in paragraph 2.
Okay.
Paragraph 2 says she consulted economic experts
Yes.
in the course of her investigation. And she says where she makes statements in her affidavit related to economics, she relies on the advice of those experts. What the affidavit then sets out is the economic expert advice of Dr. Mkhwebane,
Yes.
who is both qualified as an expert and whose report is put up. It is only in
Yes.
this court that she moved to an explanation in relation to Mr. Goodson.
Just to help me quickly, by the way, when in relation to the finalization of the remedial action was Dr. Mkhwebane consulted?
After,
After it had been circulated or what?
indeed, after the
Okay.
final report was issued, after the review litigation was instituted,
Yes.
thereafter Dr. Mkhwebane was engaged.
Came in. Okay. Anything else? That shows why personal costs, punitive costs?
Indeed.
Is
Why
there- Are these the grounds?
They are indeed, Chief Justice, and they are the grounds that persuaded the High Court to grant that order against the public protector.
Yeah. No, thank you so much.
Thank you. I'm indebted.
Mr. Ngalo?
Thank you, Chief Justice. I'll try to adopt a sort of not shotgun, but targeted approach. I shouldn't take the entire 15 minutes, should not take the entire 15 minutes, subject, of course, to engagement by the bench. Can I start at the beginning, Chief Justice and Justices?
Can I just start with questions? Why did the public protector seek to rely on Dr. Mkhwebane or put forward Dr. Mkhwebane as a person that was consulted before the final remedial action was taken, when in fact it was not so?
Chief Justice, that is precisely where I wanted to begin.
Okay.
This is all explained, but the starting point is volume 3, page 181, paragraph 126. Page 181, paragraph 126. That is the answering affidavit in the High Court proceedings, where the public protector makes it absolutely clear that she consulted with Dr. Mkhwebane only upon receipt of the 3 review applications.
That she said earlier, you see, I wanted to deal with the concern raised or the criticism raised by Ms. Hofmeyer, because she's saying, as I understand it, the public protector sought to create the impression that Dr. Mkhwebane was actually consulted before the final remedial action was circulated. Now, it was only much later that the correct version was put forward. Why did she present an incorrect version of what actually happened at the beginning?
Chief Justice, our learned friend at the Reserve Bank appear to read more in paragraph 2 of the public protector's answering affidavit in the High Court than there is. In paragraph 2, she says she received from economic experts during her investigation of the complaint. And in that, simply because she didn't qualify Dr. Goodson as an economic expert, but then later, subsequently, qualified Dr. Mokoka as an economics expert, they conflate the two and they say paragraph 2 must have been a reference to Dr. Mokoka. But our instructions, which is not in the papers.
No, before you get to instructions. When a person reads that paragraph, does a clear message emerge that Dr. Mokoka was not consulted before the final remedial action was issued? Or does the paragraph seem to create the impression that I confidently made this final remedial action on the strength of experts, including Dr. Mokoka?
In my submission, that paragraph is not reasonably capable of that construction. In other words, the construction that says that Dr. Mokoka was consulted for purposes of preparing the final remedial action. Can I cut this, well, not cut it short. The full answer, Chief Justice and Justices, it's all summarized in what is called an explanatory affidavit, which was attached to our heads of argument. But the starting point is what I've given to you, Volume 3, page 181, paragraph 126, and Volume 10, paragraph 792, 792. No, page is 792, paragraph 5. I'm sorry, Chief Justice. It's paragraph 15. It's got a number of sub-paragraphs. There's another mistake that is made. By the public protector.
Or the respondent?
Yes, no, by the public protector.
Yes.
Which then necessitated the filing of what's called an explanatory affidavit to correct any impression that may have been created. But Chief Justice, maybe let me take you there to Volume 10. Paragraph 792, paragraph 15, so that you can see exactly what I'm talking about. This is going to take us beyond 15 minutes, but...
No, the 15 minutes must cover it.
Yeah. Are we there, Chief Justice?
Yes, I am there.
There she says, with respect, the respondent misconstrues what I said in paragraph 2 and 126 of my answering affidavit in the main application. The two are not inconsistent with each other at all. They talk to two separate instances of consultation that are independent of each other. But the focus must be on 15.4 because that's where the mistake arises, Chief Justice, so I'm going to jump straight there. She says, the fact is simply this. During investigation of the complaint, I consulted with Mr. Stephen Mitford Goodson, on economics issues on 23 April 2017. He is mentioned in the report as one of the people with whom I consulted. Then, following receipt of 3 review applications, Dr. Mokoka was engaged. Nowhere have I said that I consulted with Dr. Mokoka during investigation. Then she goes on and she says, both Dr. Mokoka's and Mr. Goodson's views were taken into account in preparation for the report. Now, clearly...
I don't understand. Did the remedial action come before the report or the report come before the remedial action?
No, they both came at the same time. The remedial action is part of the report.
So
you mean Dr. Mokoka?
So when did Dr. Mokoka come in?
Dr. Mokoka came after the review applications had been filed, not before the remedial action was prepared. As she says so in that paragraph...
Sorry, both
No.
before or after the remedial action was prepared?
Dr. Mokoka was consulted after the remedial action was prepared, upon receipt of the 3 review applications.
So what is the meaning of both Dr. Mokoka's and Mr. Goodson's views were taken into account in preparation of the report.
That is precisely the mistake that I seek to explain, and that she explains in her explanatory affidavit that was filed later. But even within that paragraph, you will see that that sentence is inconsistent with what comes immediately before, because you cannot say that following receipt of the 3 review applications, you engaged with someone, and then at the same time say you took into account the report of that person that you yourself say you only consulted after receipt of the review applications for purposes of doing the remedial action.
Why so many errors, Mr.
Yes, well-
Ngalwana? Because you make an error, you're trying to clarify it, you make another error, you try to clarify, you make another error. What is the meaning of this?
The only submission I can make in this regard, this is indicative or reflective of a public protector under siege. That is the best I can do to say, because
Yes.
Chief Justice, if you go to the manner in which these 3 applications unfolded, just that paragraph,
What about the lawyer now who's settling the affidavit? Kindly say, look, your explanation doesn't make sense. What are you talking about now?
yes.
Tell
well,
us now. Let's sort this thing out. Or was the lawyer also under siege?
Chief Justice, there are internal dynamics with the client. You see, there's a client who likes to be hands-on and involved in also drafting papers, and sometimes things don't come through to the lawyers, and there are those dynamics, but I don't want to belabor that side of it.
Not too sure I understand you, but you've made your point.
Yes, thank you, Chief Justice. So, may I just ask that the justices have a look at the explanatory memo? I don't know if there has been an objection to filing the explanatory memo. I haven't heard that.
Is that what looks like a replying affidavit or what?
No, it is attached to our heads of argument, Chief Justice, and a request has been made to allow it. I haven't heard any opposition. But if it's not allowed, I simply rely on paragraph 15.4 on its own terms.
Okay.
It just simply doesn't make sense. That one sentence doesn't follow from the sentence immediately preceding it. So that's the one aspect. Regarding the recordal of meetings, may I just refer to the record? Volume 10, paragraph Volume 10, page 779, paragraph 11, where the public protector sets out how the office functions with reference to a provision in the Public Protector Act in section 7, subsection 1, paragraph B, Roman numeral 1. So it's section 7(1)(b)(1), which effectively says the public protector is the master or mistress of her own processes. She decides how to conduct an investigation. There are some meetings that she records. There are not just her predecessor too. There are meetings that are recorded. There are meetings that are not recorded. There is no malafide in that.
Can we touch on another development that is regarded as potentially malafide by the Reserve Bank, as I understood their submissions? It is this. The provisional report did not have some of the decisions that form part, call them decisions, call them recommendations, that form part of the final remedial action that potentially affected the Reserve Bank in a negative way. Now, why did she not say, Reserve Bank, after further reflection, I've decided to strengthen the remedial action that you had sight of in the provisional report? If you have any comment, this is what I am minded to do.
Two things, Chief Justice, in answer to that question. Firstly, a provisional report has absolutely no legal status. It's akin to a draft judgment by a judge.
Sure.
That's the one thing. So
Yes.
the exercise of taking a preliminary report and comparing it with the final report and then say simply because what is now in the final report was not contained in the provisional report, therefore indicates some bad faith or something of that sort, is, with respect, inappropriate. It's not a necessary, it doesn't follow. That's
Sure.
simply because what was in your provisional judgment, what is now in your final judgment was not in your provisional judgment, therefore you acted in bad faith. But
Yes.
as regards not putting this, the Reserve Bank was given an opportunity, as everyone is given an opportunity in terms of Section 7, subsection 9 of the Public Protector Act,
Yes.
to comment on the provisional report. That's not done anymore because it creates this expectation that there is what is contained in the provisional report is going to be carried through to the final report. So the Public Protector's Office, we are instructed, doesn't give people provisional report anymore. They simply set out to them that these are the issues that we need you to comment on. What do you say on these issues?
No, that I understand. I'm sorry to interrupt you, Mr. Ngalwane. You know, I'm just saying, isn't it understandable that the Reserve Bank would expect to be given an opportunity to comment if something potentially worse than what it had been given reason to believe might be the outcome is subsequently decided upon or contemplated. To say, look, you know, all along it looks like we've been a bit light on you. We are minded to be more drastic now. Do you have anything to say? I'm putting it no higher than that. I'm saying, isn't it a reasonable expectation to be entertained by the Reserve Bank to say before you collapse, you faint because something worse than what you thought might be the outcome is actually what is going to be the outcome. We want now to prepare you. Fasten your seatbelt. This is the likely remedial action. Do you have anything to say?
Chief Justice, let's look at what the remedial action is. Because the Public Protector says the Reserve Bank wasn't implicated in this at all. Let's look at what the remedial action. The remedial action is targeted at the Special Investigating Unit and the Portfolio Committee on Justice and Correctional Services. All the Reserve Bank is required to do is to cooperate. There is nothing of substance that is demanded of it. The remedial action, if I may, it's in paragraph 7.1.1. It says the Public Protector refers the matter to the Special Investigating Unit in terms of Section 64C2 of the Public Protector Act to approach the President in terms of Section 2 of the SIU Act to reopen and amend the proclamation in order to recover misappropriated funds unlawfully given to ABSA in the amount of 1.125. 2, to reopen and amend the proclamation in order to investigate alleged misappropriated public funds given to various institutions. Then, in respect of the Reserve Bank, it says the Reserve Bank must cooperate fully with the Special Investigating Unit.
You see now, as I understand, Ms. Hofmeyer did not quite put it this way, but I think what I'm going to put to you is not far removed from what falls within the contemplation of what she was saying. It's basically say, look, if you're going to have me now investigated, so to speak, people who ordinarily investigate those allegedly involved in serious misconducts that touch on money, at least allow me to counter that, because nobody likes to be known to be under some investigation. Allow me the possibility to defeat, if I can, that possibility. Nothing more.
Yes. Chief Justice, again, two things. Let me start with the second one first. Let's assume, well, not assume, because that's what happened. The South African Reserve Bank wasn't given an opportunity to comment on whether or not it should cooperate fully with the Special Investigating Unit in doing its investigation. That, in our submission, is merely a procedural irregularity.
I was starting much earlier.
Yes.
Just the recommendation that something must be done to the South African Reserve Bank, that the SIU must investigate them before you even come to the instruction that they must cooperate.
Yeah, but
Is that not something they ought to have been given the opportunity?
Well, the Reserve, I'm sorry, Chief Justice. The remedial action doesn't order that anything be done to the Reserve Bank. The remedial action directs that an investigation be done in respect of funds given to ABSA.
Who?
It doesn't say. But
No,
we know,
but we know.
Yeah, but we know, yes. We know it was given by the Reserve Bank.
That's my point.
Yes, but Chief Justice, they should have been given an opportunity to respond. They ought to have been given an opportunity to respond, which is the same thing. But the fact that they were not given an opportunity to respond does not amount to bad faith. It doesn't amount to bias against them, because the public protector, as she says, because she didn't make a remedial action targeted at or against the South African Reserve Bank, she did not consider it necessary to invite them to comment on this. She may have been mistaken, both in fact and in law.
Let me ask a different question.
Yes.
What have you to say to Ms. Hofmeyer's submission that it was inappropriate for the presidency to even be afforded the opportunity to express a view in relation to the powers of the Reserve Bank or constitutional amendments?
My understanding of the papers is that the public protector did not discuss the remedial action or the powers of the Reserve Bank with the presidency.
Ms. Hofmeyer says if you look at the 8-page notes, handwritten notes, it emerges from there, unless I misunderstood her, that the legal advisor of the presidency commented on this, or in the course of their discussion, this thing emerged.
Well,
Did I misunderstand Ms.
no,
Hofmeyer?
maybe not. That's also how I understood Ms. Hofmeyer. But inferring something or reading something from a document and drawing a conclusion from reading that document is not quite the same thing as what the document actually says or what the person who produced the document meant by it.
I wanted to, let us assume that there was a discussion about this issue between the presidency and the public protector. Is it an appropriate discussion or an inappropriate discussion?
as counsel, I don't see anything inappropriate in doing it. Perhaps the public protector may have, or the South African Reserve Bank has a different view on it. Because
Say
at
the
end of
power
the
to
day-
the power to do anything about the powers of the Reserve Bank lies with Parliament, not the presidency. So why discuss that with them?
That is correct. Well, of course, we are still on the terrain of assuming that this was indeed discussed,
In line with the notes.
in line with what is perceived the note to be saying. But if we are on that terrain, at the end of the day, Chief Justice, it is the President that would have to sign legislation into law. It is correct that it is within the compass of Parliament to deal with legislative amendments and constitutional amendments. But it doesn't make it inappropriate to discuss an issue that will eventually end up with the President to dealing with it, because the fact that the President, let's assume the President says, yes, I agree with you on your remedial action as regards the constitutional amendment, it doesn't mean that's what the Parliament is going to find, because it's an issue that Parliament will have to debate, opposition parties and ruling party, and then come to a conclusion. All the President has to do is to simply sign it into law or check whether it is constitutionally palatable. If it isn't, send it back to the National Assembly to have a look at it, and the state law advisors and so on.
No, they do much more than that. They can initiate legislation, but couldn't the public protector be seen as lobbying the President, as head of the executive, to initiate a constitutional amendment? I'm just thinking aloud.
That, I don't have instructions on that.
Well, could she reasonably be viewed as having tried to lobby the President in this connection? Or is it far removed from the facts as we have them?
Yes, it's very difficult in my position to think about what a reasonable person would infer from the conduct of the public protector. If I take myself as a reasonable person, perhaps I'm not, I wouldn't think that to amount to lobbying the President. It would simply be to getting the view of the one person who is a stakeholder, and then failing to take the view of another stakeholder in the form and shape of the South African Reserve Bank. It gets back to the same argument or the same issue that says, does that constitute bad faith? What it does is it constitutes failure to act in accordance with the canons of natural justice, to give the other side an opportunity to comment on your remedial action. But it's nothing more than a procedural irregularity. And of course we know through the cases that even where there is procedural irregularity, if no prejudice is to be found, a review application is unlikely to be granted. Now, what would the prejudice have been in this case? Because all the public protector does is to direct the SIU to do an investigation to recover the funds that were granted by the South African Reserve Bank.
Something that I should have raised with Ms. Hofmeyer, but now occurs to me, and unfortunately it's your line of thinking. How different, should I put it that way? It's like I'm repeating your argument, although I don't want to. On the basis of what the High Court decided, and knowing what has been the fate of a number of High Court and SCA judgments at a constitutional court level, would you say that the likelihood of judges and magistrates being held to pay costs from their own pocket would remain the same or heightened if the High Court order is upheld?
When the Chief Justice say would remain the same or heightened in what respect?
Would the principle remain undisturbed in terms of which you would ordinarily hold magistrates and judges accountable? Or is there a likelihood that judges and magistrates will now find themselves having to pay costs from their pocket more often if the High Court decision is upheld?
Well, Chief Justice, if the law reports are any indication and the number of judgments that have been set aside are any indication, one is most likely to find that judges are operating increasingly under the real threat that they will have to pay personal costs if they make a wrong decision. Now, who is then going to take the risk of developing the common law as Section 39 of the Constitution enjoins the judiciary to do? Because everyone will be concerned about, look, if I develop the law, there is a chance that the higher court may set me aside and therefore order me to pay personal costs. With respect, it's undesirable. I make one simple example. Let's take it a notch lower from the judiciary. The Auditor General, for example. The Auditor General appoints private auditing firms to perform certain audit functions because it simply doesn't have the capacity to audit all the organs of state. Not so long ago, it terminated some of those auditors' services or contracts. Now, KPMG, for example. If KPMG were now to decide that, look, the basis on which you are setting, you have terminated my contract, is not bona fide, you are simply being led by the nose by what is contained in the media and social media, I'm taking you on review, and I'm going to request for you, the Auditor General, the person of the Auditor General, to pay costs directly from your own pocket. Now, how is the Auditor General to be expected to perform his functions without fear or favor from then on? Whether or not the cost order is granted against him personally, but the threat of it, the fact that that is even fathomable, is, with respect, a deterrent to a constitutional being, whether it be judges or Chapter 9 institutions or heads of Chapter 9 institutions, to perform their constitutional functions without fear, favor, or prejudice.
Now, just this narrow one. Why didn't the Public Protector just disclose the meeting of the 7th of June? I had this meeting with the President.
Yes.
Why?
Because
Why must it appear in the notes, handwritten notes? Because you see, it's a factor that is relied on to say, you see now, she was being secretive.
Yes.
She was doing something that she knows she ought not to have done. That's why it was kept away from the other parties. Can you just explain that one?
Why she didn't disclose the meeting
Yes.
of April?
In line with everything else.
Yes. Well, because the April meeting, she considers...
No, the 7th of June. That one was, the April one was a meet and greet.
The April one was...
The 7th
meet
of
and
June.
greet, but, yeah. I understood my learned friend to be going to the 7th of June,
Yes.
the April meeting, and then point to PP8 and say...
No, let's focus on the 7th of June, because my understanding is that she's focusing on that one to say, you see, now it was a simple thing for the Public Protector just to say, we met with the presidency on the 7th of June, and this is what transpired. What should we make of the non-disclosure?
She could have disclosed the meeting, Chief Justice, to be frank, but in her judgment, she considered that it wasn't necessary because she didn't discuss, according to her, she didn't discuss the meat of the remedial meeting. Now, of the remedial action.
Is that
But let's assume-
reconcilable with the notes?
I beg your pardon?
I mean, whatever explanation you provide must take cognizance of what the handwritten notes contain.
Yes, of course.
Yes.
Yes. Remember, I did say initially that the notes are what our learned friends mean what our learned friends infer from them. The public protector looks at these notes and says, this doesn't disclose the fact that we discussed remedial action with the presidency. But assuming that the notes mean what the South African Reserve Bank says they mean, in other words, that they are indicative of a discussion with the presidency of the remedial action, then she should have disclosed it. But the question that remains, Chief Justice, is what we always come back to is, does the fact that she didn't disclose that meeting indicate that she was acting in bad faith or that she was lobbying
Yeah.
the
Well,
president?
let's just narrow it down to whether it shows bad faith or not.
Yes.
Does it or doesn't it? Why not disclose?
We're saying it doesn't show bad faith.
What does
It
it
shows
show?
bad judgment.
Bad judgment.
That is the highest we can place it. It shows bad judgment. And bad judgment is not to be punishable by an adverse personal and punitive court order. I see, the issue of vulnerability, if I may move on, Chief Justice.
Mr. Mkhwebane, may I ask a short question?
Yes.
Just arising from the debate with the Chief Justice, the principles of cooperative governance in Chapter 3, Sections 40 and 41, they are applicable when the public protector deals with another state institution?
Absolutely, no, they are correct.
Thank you.
Justice. And so one would have expected that the Reserve Bank would have approached the public protector in terms of those sections, Section 41 in particular of the Constitution, and say, I beg your pardon?
The other way around.
Or the other way around. Both of them could have approached each other and say, look, this is not the way to go about things. Let's try and resolve this issue instead of running to court. Regarding the vulnerability, the public protector explains this, and I'll just give a reference to the record. It's volume 10, page 783, paragraph 13.2.2. The public protector wasn't plotting the downfall of the South African Reserve Bank by discussing vulnerability, as the notes say, of the Reserve Bank. She places a context to it and talks about Judge Heath's media statement talking about a run on the banks. That's the vulnerability that he was talking about. That's what the public protector says it was about. Regarding the no explanation on the meetings with the SSA, again, volume 10, page 779, paragraph 11, and volume 3, page 199, paragraphs 173 to 175. A question was put to our learned friend by Justice Theron about whether the court found that there was any bad faith. And the court was taken to paragraph 128, I think it was. Just a minute, 48. But let's look at what the basis for saying that the public protector, in fact, it doesn't even say that. Paragraph 128 in the relevant, I'll just read the relevant part. The court says it's at 617 of volume 8. The court says, sort of halfway down the page in paragraph 128, Section 5(3) of the Public Protector Act provides for an indemnification with regard to conduct performed in good faith. The Public Protector has demonstrated that she exceeded the bounds of this indemnification. It will therefore be of no assistance to her. It is necessary to show our displeasure with the unacceptable way in which she conducted her investigation, as well as her persistence to oppose the 3 applications to the end. Now, clearly, assuming, and we don't accept that the High Court by this paragraph found that the Public Protector acted in bad faith. The High Court is simply setting out what Section 5(3) of the Public Protector says, or Public Protector Act says. But assuming, for the sake of argument, that the High Court said there that the Public Protector acted in bad faith and way beyond the protections afforded by Section 5(3) of the Public Protector Act, let's look at the basis, the factual basis upon which the court makes that determination. There are 2. The one is that she conducted herself in an unacceptable way in the investigation, not in the conduct of the High Court, in the investigation. Now, I've referred the court to Section 7(1)(b)(1) of the Public Protector Act, which effectively says the Public Protector is the master of her processes in doing an investigation. What the High Court seeks to do is to impose upon the Public Protector the manner in which she should have done the investigation. On the prompting of the South African Reserve Bank.
While you are just there, I'm sure you understand when I interrupt you, Mr.
Yes,
Mkhwebane.
no, I do.
Thank you very much. You know, so you don't see it as an obligation she had to consult the Reserve Bank. You see it as one of the options she had. It was up to her whether to consult or not to consult, in other words.
Because on the facts, she considered that it wasn't necessary to do so. But had she made a direct remedial action against the Reserve Bank, say, for example, I direct the Reserve Bank to recover the money, there she would have been under obligation to consult with the Reserve Bank. That's effectively what she's saying. But she wasn't targeting the Reserve Bank in her remedial action. And so she considered that it wasn't necessary to do so. I readily concede, Justice Froneman. Sorry.
Justice Froneman.
Chief Justice, I'm sorry. I often field questions from Justice Froneman when I'm here, so Chief Justice, you look nothing like Justice Froneman. Chief Justice, I readily concede.
And I haven't asked a question in the last hour.
Yes. I readily concede that where a remedial action is to be made against a specific institution, there is an obligation to test the remedial action that is being contemplated against that person or against that institution. But does that amount, if that obligation, because there's nothing, if that obligation, let's put it this way, if that obligation is not heeded, the question that keeps coming back is whether that amounts to bad faith. Is that a breach of a constitutional duty? I know there is this reference to Section 181(2) tool to act impartially and without fear, favor, and prejudice. The public protector, let's put it strongly, and said, failed to consult to hear the Reserve Bank on a remedial action that may eventually have an effect on it. But that is something similar to when an administrator does not give audience, having heard one side of the story, or a decision maker, or a judge, not giving an opportunity to the one side to say something in respect of a particular issue, but having consulted the other side. This is precisely what happened in Basson 2, where there is evidence that is admitted, taken by commission, but then Dr. Basson isn't given an opportunity to test that evidence. And the court found, this court, found that there's nothing biased about that. There's nothing bad faith about it. So I don't want to be seen to be unduly protective of the public protector. I concede that if this remedial action was targeted at or would have adverse effects on the South African Reserve Bank, they should have been consulted. But failure to do that, my point is, failure to do that doesn't mean it was a breach of 1812 of the Constitution.
Let me just be wild in my thinking. In a criminal case, you do give people some kind of a second opportunity. No previous conviction, and so on and so on. What is the worst censure, second to punitive costs from own pocket, that ought to have been imposed on the public protector if we're satisfied, or any court is satisfied that what she did was wrong, and any court must mark its disapproval of her conduct? What is the worst short of what she was given?
Judicial rebuke.
Judicial rebuke.
Yes, Chief Justice. Because in our submission, judicial rebuke goes a long way to alerting the person who's performing this function to up her game, as it were, and not err on that side again. I suspect, and I don't know this for a fact, I suspect the judge who was criticized in S versus Basson, the likelihood is that he probably never did what he did again. But the short answer is judicial rebuke, Chief Justice. So that is the first point.
Stern criticism, firm criticism.
Very firm criticism. So the one basis on which it is suggested by our learned friend in the way she reads paragraph 128 of the judgment is that the public protector acted not in good faith because of the unacceptable way in which he conducted the investigation. That's the first point which we've just dealt with. The second is her persistence to oppose all three applications to the end. Why shouldn't she? When two judges, independently of each other, found that this lifeboat was unlawful. And there was a debate here, while I'm on this point, about whether the money has been paid. Why would the public protector go and investigate and order the recovery of money that has not been paid? The public protector says...
That has been paid.
I beg your pardon, that has been paid. I'm sorry. I feel under siege. volume 10,
Let us, okay, give us the side,
volume 10, page 770, paragraph 8.6 and following. 8.6. It's got a whole lot of subsections. It goes on until page, it's a long explanation. Where she says the money wasn't paid as far as she's concerned.
let us assume that she was wrong. What should we make of it?
Then she was wrong in law. That remedial action has been set aside on review. That's the end of that matter. And it's not on appeal for that very reason. Now, so our submission is any argument that she acted in bad faith, as the High Court presumably says. She acted in bad faith because of the unacceptable way in which she conducted the investigation and because she persisted to oppose all three applications is with respect inappropriate.
What should we make of the 1.3 billion loss in relation to how she handled the matter?
Well,
Remember, Ms. Mayor made the point about the impact of the proposed constitutional amendment on the I think it was government investment or something.
yes. Well, that, Chief Justice, takes me to what I was going to end with. And it is this. If we look at the judgment in paragraph 123, the judgment expressly declines to review and set aside the remaining part of the report. So in other words, it only sets aside the remedial action targeted at the SIU and the parliamentary committee. But it leaves intact the findings and the observations made by the public protector in that report. Now, the public protector is keen to learn what is to become the fate of the rest of the report that has not been set aside. Is she at large, on the basis of those findings, which have not been set aside, and on the basis of the observations she has made, to make another remedial order, or take another remedial order for the recovery of those funds?
Is that in your prayers? Just remind me. Is that what you're asking for in your papers?
No, Chief Justice, we don't ask for that at all.
So,
But it is something that is consequential upon the order of the court. There is no appeal or cross-appeal by the Reserve Bank about the rest of the report, that the High Court should have set aside the rest of the report, including the findings and observations. I'm happy if the Constitutional Court decides that simply, well, not simply, because that is not the order that the public protector has sought, you're not going to deal with it. But it's just that
nobody is interested in an order being made in relation there to, and isn't it the remedial action that matters the most?
Yes. Well,
If
public-
the remedial action, which is like the engine,
Yes.
collapses, the vehicle won't move, it's finished.
well, Chief
Is
Justice,
that not the logical consequence?
it is indeed.
Yes.
Chief Justice has spoken. The representatives of the public protector are here. They've asked me to raise the issue because it's of concern to them.
Didn't she, or she is not pursuing anything herself?
No,
The only thing she's pursuing is a cost order.
she doesn't want to have court order, and
Yes.
she doesn't want to be declared to be.
Sure. So shouldn't we just focus on that?
Yes, Chief Justice. Unless there are any other questions, Chief Justice, I am done. I'm sorry. Oh, yes. We make the same argument in respect of personal cost in these proceedings.
Yes, sure. Thank you,
Unless
Mr.
there's-
Ngalwana.
Thank you, Chief Justice.
Thank you. Judgment is reserved and the court adjourns.